You so much. Good afternoon, everyone. My name is Samantha Rogers, and I'll be presenting today on money matters for other legal remedies, criminal law, employment, tort, and more. So the Money Matters project focuses on the financial impact of sexual assault and examines the economic empowerment of survivors. Sexual assault has serious financial costs to survivors, and this project aims to increase the financial stability and security of sexual assault survivors to support their recovery and prevent future violence. This goal is supported in part by educating attorneys and advocates about legal remedies that are available to support survivors' financial independence. Our objectives for today's training are to build upon prior Money Matters trainings on financial legal remedies available to survivors, discuss other areas of the law where financial compensation or damages may be an option, and identify those available legal remedies. As always, for our core reminders, the law is always changing. Always check the law for the most up-to-date information. It is crucial to properly complete and file the proper financial statement in your family law and protective order actions when there is a duty to support. And undocumented survivors may face restrictions and their options may be impacted due to immigration status. Always check eligibility requirements before advising undocumented clients. To start, we'll be talking about criminal law and potential remedies available there. A survivor who has incurred expenses as a result of a crime has options for financial relief, one of which of those is restitution. Restitution requires a criminal conviction, and this is money paid by the perpetrator to the victim as a part of a sentence. So this is as part of a punishment, not compensation. If a defendant or perpetrator lacks any money, they unfortunately cannot then be ordered to pay restitution. Some expenses that restitution covers includes medical, counseling, dental, and hospital bills, any loss of earnings, rehabilitation costs, any property that was stolen, damaged, destroyed, converted, unlawfully obtained, or substantially decreased in value as a direct result of a crime, and any direct out-of-pocket costs. A survivor needs proof of costs in order for a successful restitution claim, and those proof of costs can include bills, pictures, receipts, police reports, insurance claims, employer statements on lost wages, to name a few examples. Additionally, sometimes, as we've discussed before, restitution may not be an available option if there is a lack of an ability to pay or if there is no criminal conviction. Another potential option for victims of crime to recover is the Criminal Injuries Compensation Board, or CICB. The CICB is a remedial body in the Governor's Office of Crime Prevention, Youth, and Victim Services. They provide compensation for crime victims. The CICB is what's called the payor of last resort for out-of-pocket expenses. This means that if a crime victim or survivor is able to get reimbursement from other means, such as insurance, private suit, or restitution, the CICB will not pay. Part of the requirements for filing requires reporting to police within 48 hours of the crime occurring, unless there is good cause shown. Additionally, the victim must file within 3 years of the discovery of the crime. However, in Sally's experience, sexual assault and child sexual abuse can qualify as good cause to waive the requirements for the 48-hour police reporting and for the 3-year filing requirement. It is unclear under the law whether a SAFE or a sexual assault forensic exam is enough to satisfy the reporting requirement under Maryland law. As a note, though, a survivor should never be billed for a SAFE. And if that does occur, CICB may be an option if a survivor is billed and reimbursement from the hospital is unsuccessful. Some of the costs that are reimbursable under the Criminal Injuries Compensation Board include medical expenses, therapy expenses, loss of earnings, bereavement leave, disability, funeral costs for homicide cases, loss of support claims, and lost wages for a parent caring for a child injured by a crime. Unfortunately, costs that are not reimbursable include property loss, transportation costs, lock changes, relocation costs, childcare expenses, and pain and suffering damages. There are caps for what is reimbursable under CICB, which are important to note when advising your clients. Employment also offers another potential way for survivors to gain financial stability. In cases of sexual assault or sexual harassment, these form the basis for a discrimination claim on the basis of sex. In the employment law process, there is an administrative process that acts as the precursor to any litigation, meaning that a claimant must first go through this administrative process before they can file suit. Additionally, in an employment law claim, the action is against the employer, not necessarily the perpetrator. There are different kinds of discrimination claims, one of which is quid pro quo, which means that an action is taken against an employee for refusing to submit to sexual demands. The other is creating a hostile work environment, which includes unwelcome conduct by the employer or another employee to the victim. There are a couple of different options for filing in this administrative process. One is under the federal system with the Equal Employment Opportunity Commission, or EEOC. Under Maryland state law, there are also options for filing, one of which is the Maryland Commission for Civil Rights, MCCR, and additionally, there are county equivalents that have offices that can also process these claims. Counties with these offices include Howard, Montgomery County, and Prince George's counties, as well as Baltimore City. Please excuse me. When filing for an employment claim, there are differences when filing in the federal system or the state system. As I said before, there are differences when filing in the federal system and the state system. For federal claims, claims are filed with the Equal Employment Opportunity Commission. A claimant would have 180 days from the harassment to file their claim. Additionally, an employer must have at least 15 employees in order for a claimant to file with the EEOC. Please excuse me. Additionally, to prove harassment, a claimant must show that the conduct was either severe or pervasive. And this standard requires that the conduct was severe or pervasive enough to create a hostile work environment. Additionally, to make that determination, certain elements are considered. To contrast, when filing under the state law system, a claimant would file with the Maryland Commission for Civil Rights or the county equivalent office. For harassment claims specifically, the complainant would have 2 years to file. And additionally, the employer only needs at least one employee in order to be eligible to file. Another difference that under the state law standard, Maryland uses the totality of the circumstances standard when evaluating claims. This standard is a lower bar than severe or pervasive, and the totality of the circumstances looks to whether a reasonable person would perceive the environment as abusive or hostile. In an employment suit in an admin process, potential remedies include firing the persons responsible, updating complaint policies, any potential monetary awards, which include back pay, front pay, compensatory damages, punitive damages, and attorney's fees. Compensatory damages would include things, for example, if the complainant was fired from their job or quit as a result of the harassment and had to search for a new job, any costs related to their job search could be considered compensatory damages. It's important to note that a survivor's immigration status limits the ability to collect back pay. That is something to note when evaluating any potential monetary awards in an admin process. Another potential option is in tort. A tort is a lawsuit for money, and tort suits may not always be an option for survivors, but when available, can significantly change a survivor's financial stability. Tort law often has difficult statutes of limitations, and attorneys must advise survivors about available torts and statutes of limitations. For sexual assault claims, the available torts include a claim for assault, which has a time limit to file of 1 year from the date of the assault. And another additional claim includes claims for battery or potentially negligence. And these torts have a time limit of 3 years to file. Child sexual abuse has different statutes of limitations. For child sexual abuse specifically, House Bill 1 and Senate Bill 686 eliminate the statute of limitations for child sexual abuse as of October 1st, 2023. This law also provides that the new statute of limitations can be applied retroactively, meaning that suit can be brought at any time, even if the statute of limitations expired under the old laws. This is huge for any child sexual abuse survivors that previously may have had a claim that expired under the old schemes. They now would be able to bring suit under this new statute of limitations. However, it is important to note that there are currently challenges with this new statute of limitations. One of which is that there's currently a challenge to the retroactive application of the law as unconstitutional. Additionally, something else to note with allegations of child sexual abuse from the Catholic Church, the Archdiocese of Baltimore has filed bankruptcy, which significantly limits recovery for child sexual abuse survivors. At this point, with the challenges to the statute of limitations law for child sexual abuse, we'll have to wait and see what challenges may be successful and how the landscape of the law will change. For suing the government specifically in tort, there are special rules that survivors must be made aware of. This includes a notice requirement and other special rules. The notice requirement for suing the government requires a potential plaintiff to submit a written claim to the treasurer within 1 year of the injury. Upon denial of the claim by the treasurer, that plaintiff can file suit within 3 years of that denial. There are also special rules regarding liability as well. Damages are limited to $400,000 for a single claimant for injuries from a single incident. It's important to note that for child sexual abuse damages, those damages are limited to $890,000 for a single claimant for injuries from a single incident. Additionally, state employees can be sued personally for actions that take place as part of their state work. However, the plaintiff must show that they acted with malice or gross negligence in order to be sued personally. Actual malice is defined as ill will or improper motivation. To illustrate when a tort claim would fall under standard tort or the Maryland Tort Claims Act, we should consider the following hypothetical examples where a victim has been sexually assaulted. In these examples, there's certainly no guarantee a suit would be successful. This is for purposes of evaluating whether these hypotheticals would arise under standard tort or the Maryland Tort Claims Act. For example, an instance, there is a parking garage owned by a private company where security cameras aren't working when the assault takes place. A private citizen harms another private citizen, or a state employee harms another person while out on a date. These are all examples that would fall under standard tort. For example, for instances where a state employee in the government harms another person while at work, a state employee at a government agency harms another person while at work, or a police officer, for instance, harms a person while in custody and while they are on duty. These are claims that would fall under the Maryland Tort Claims Act and thus would follow the notice requirements and would be subject to the damages cap under that law. Another point to note is under education. Student loans can be, as we are all aware, a huge barrier to achieving financial stability, especially in cases where a survivor may have experienced a sexual assault on their college campus. There is currently a bill that has been pending in the House for student loan deferment for Sex-Based Harassment of Survivors Act. This proposed bill would allow deferment for student loans up to 3 years for survivors of sexual assault, which would provide some relief after a survivor experiences trauma. This is a bill to watch and is still pending, so something to keep our eye on this year in this session. This is the last in a part of an ongoing Money Matters series, which includes other trainings in this series that are recorded on our website. We also have a web page that you can visit on our website for additional resources. At this time, I'm happy to take any questions, or if there are any questions, you can email me at my personal email, srogers@mcasa.org. I see that there isn't a question from an attendee for torts. When did the terms start to count? This is a great question. The time limits start to count at the date of the incident. So from the date of the sexual assault. That's a great question. Thank you very much. Alyssa has included the anonymous evaluation form in the chat. If there are any other questions, I am happy to answer. Otherwise, please feel free to send me an email.